This video is made possible by Practical Defense Systems, the best online security training at the lowest prices. You can start your security career today online at pdsclasses.com. Check them out. Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support of GunGuyTV. I really do appreciate it. Yes, we had a kind of a partial victory for concealed carry permit holders in California in the concealed carry sensitive places arena. I brought Chuck Michelle. I'm going to talk with him in just a minute. We're going to give you some specific answers on where we won, where we lost temporarily, what the battle entails, and what you can and cannot do legally now if you have a concealed carry permit. So stick with me. I do want to remind you that YouTube tends to ban me. They just tried to shadow ban a video the other day. Fortunately, I was able to get them to retract that, but most of the time they just ignore me and shadow ban it anyhow. So I do urge you to check me out on Rumble and X. Those are better platforms. In both cases, they don't censor me, never have, and probably never will. So I'm urging people from YouTube, even if you stay on YouTube for other stuff, jump ship off of YouTube, go over to Rumble, go to X, subscribe to my channel over there. You'll find links in the description. All right, let's go talk to Chuck. Chuck, thank you very much for joining me again, man. It's been a long time. It's good to see you, and I'm glad to have you on. And we got some victory to talk about, which is good. We had, it's partial victory, but obviously I was looking at it could be a lot worse. I noticed your post on X yesterday, and you said we won on hospitals, churches, medical facilities. This is the whole concealed carry, try to make the whole place in California a sensitive place thing. Let's see, hospitals, churches, medical facilities, public transit, gatherings that require a permit, parking areas attached to those places, and the vampire rule I want you to explain at some point. And then where you say we lost was on, at least temporarily anyway, was on bars and restaurants that serve alcohol, playgrounds, parks, state parks, casinos, stadiums, and arenas, libraries, zoos, museums, and the parking areas attached to those. So there you go. There's the wins and losses. So what's the deal? I'm going to shut up and let you tell us what happened.
Well, first of all, folks need to recognize we're not talking about banning guns for everybody. Most of these places, most public places, you cannot have a firearm unless you have a permit, a license, a CCW, which means you've gone through the training, you've qualified through whatever hoops the issuing authority wanted you to jump through, good moral character, or you're just not you're not prohibited from possessing firearms generally. You have to pass, you have to be vetted, and then you get this license. It's a lot easier than it used to be because the Supreme Court in Bruin said that the states have to issue these licenses. They cannot require you to have some special need because it's not a privilege, it's a right. So as long as you're otherwise generally qualified, you can get a license, a CCW, to carry concealed weapon in public without proving some special need, just for self-defense or to defend your families. So the blue resistance to that, the Newsom and his cronies' resistance to that was because now people can, in California and across the country, can apply for a license in states where they couldn't before. And so in California, there's several 100,000 more people, and we needed to be millions of more people. But several 100,000 more people have gotten CCWs, and Newsom and his cronies don't like that. So they wanted to try and make CCWs useless. Remember, for 100 years, it's been this way. All of these places that now some are prohibited and others aren't, all of those places, if you had a CCW, you could go in with that CCW. Couldn't go in without one, but you could go in if you had a CCW. And there was no problem with any of that. There was no CCW holder crime spree, no incidents related to any of these areas. But they wanted to make it so that people would be discouraged from getting a CCW because it wouldn't be valid, it wouldn't be useful in so many places. So they passed this law to ban CCWs. It basically invalidates CCWs in all these areas that they falsely claimed to be sensitive, because the Bruin decision did say that you can ban guns, even those possessed by CCW holders, in certain sensitive places. So the state's gambit was to try and designate as many places as possible as sensitive places where CCWs would not give you the right to carry a firearm into those places. So we immediately challenged that. So did the lawyers in Hawaii, Alan Beck, and the Walford matter in Hawaii, and FPC in the Caballeros case in California. So there was 3 cases that all, the CRPA's case, Second Amendment Foundation, all went up to the Ninth Circuit, and we won in the district court. The district court said these places are not sensitive. There's no historical analog where they've been banning these kinds of places from having guns held by a licensed gun CCW holder. That's a big distinction, and the court kind of blurs it, because it doesn't necessarily talk about whether or not there's a historical analog for someone to have a license and have a gun in one of these places, as opposed to just unlicensed people just being able to carry in these places. And that's the big distinction, and that's the big problem, and that's the big fake news that's been out there, that all these places anybody could carry a gun for 100 years willy-nilly, and now we finally need to stop all these people from carrying guns. Well, no, it was never all these people. It was just people with a license. Anyway, so we won on a lot of these places, which is very encouraging. The state cannot invalidate your CCW in the places that you mentioned, but there's going to be problems with, bars and restaurants that serve alcohol. Okay, you're going to a restaurant that serves alcohol. You're not drinking, but you can't leave your gun in your car locked up in your glove box or otherwise secured in your car while you're going to the restaurant, or to a park, or to a casino, or to a library, or a zoo, or a museum. You can't leave it in your car locked up. That's a problem. That means you can't take the gun with you on the trip to those places. So it's going to inconvenience people fairly significantly, and we're going to do what we can to open it up to the rest of those places, because we believe that this court, we faced a very hostile 3-judge panel. Frankly, I'm kind of surprised we won on as many things as we did. But we have a couple of options. We can take it directly to the Supreme Court, which that's not really the wisest choice. We may go en banc, which probably may be necessary for Hawaii, because Hawaii is in a little bit of a worse state than California is. Or you go back to the trial court and you litigate this, and you show where the Ninth Circuit was wrong to the trial court judge, and then get a final judgment, and then you appeal that again, and then you can go to the Supreme Court, because the Supreme Court is not taking these cases that are just rulings on preliminary injunctions. They're showing a very disinclination to take one of those cases. They want a case with a final judgment, which is why the Bianchi case, the Maryland assault weapon case, is in such a good spot in the Supreme Court right now. And that's, if you saw the CRPA magazine this month, on the cover is the big Bianchi, the takeoff on the big Lebowski. It's a bowling picture, and it says, "Will the Supreme Court finally strike down a semi-auto ban?" But it still comes down to, a lot of this is the methodology, and whether or not the methodology of Bruen is being applied properly by the lower courts. And there's a huge feud going on in the Ninth Circuit right now between several of the conservative justices versus the liberal justices about how Bruen is supposed to be applied.
You mentioned a couple of things, Chuck. One, you said that the Supreme Court, you said going to the Supreme Court would be unwise. And then you mentioned that they don't want to take cases that are just preliminary injunctions. So I guess my first question would be, so was this actually a fight over a preliminary injunction at the Ninth Circuit?
Yes.
So that's why going to the Supreme Court would be unwise, because they wouldn't take it anyway, and they just bounce it back.
Unwise at this time, because It's not in the right procedural posture. The Supreme Court has made it pretty clear, because it's turned down a lot of Second Amendment cases that were appeals from preliminary injunctions. And some of the judges have said, bring this back once you've got the judgment from the trial court, the final judgment, not just a preliminary injunction.
This gets back to that whole half-baked cake kind of a deal. It's not
exactly. Yeah,
it's not ready for them yet.
A preliminary injunction is a win, but it's not a final ruling. You got to go. You file your complaint. You seek a preliminary injunction. You either get one or you don't. Either way, if you get one, the state can appeal. But you're appealing. It's called an interlocutory appeal. The case down in the trial court isn't over yet, but you're up in the Court of Appeals before the trial court works its way through the whole process. So if you stayed in the trial court, you get the preliminary injunction, then you would work for a permanent injunction and judgment. That's the final thing that's the final act that the trial court does. Then you appeal that. You appeal that judgment to the Court of Appeals. That's the kind of thing that the Supreme Court likes, because
I get it. So I'm a little confused as how we ended up in the. How did we end up in the Ninth Circuit to begin with? Is that because the state asked the Ninth Circuit to look at it because we won at the lower court?
Yes.
So where does it go now? You've given some options there. Obviously, the Supreme Court's not a good choice, but you mentioned being able to go back to the original court and finish litigating the case. We think
that what the Supreme Court has been telling us is finish the case in the trial court. Make the record. Explore all the evidence. Put it all into the record in the trial court. Then appeal it, then to the Ninth Circuit, and then bring it to us. And so there are several cases that are that far along. Duncan is one of them, the magazine capacity limitation case that the CRPA has been funding for 15 years.
Right. Yeah.
I mean, 10 years. And then the Bianchi case, which is the Maryland semi-auto case, that's gone back down. It was up, it went back down. They finished up the trial. Now it's back up, and they've asked the Supreme Court to review that. And CRPA and the Second Amendment Law Center and everybody will be asking the Supreme Court to take that case. And then if the Supreme Court takes that case, they'll be submitting amicus briefs to help win that case, because that would take care of a lot of problems with semi-auto bans in Illinois, in California, in Oregon, in Maryland, there's 3 or 4 more states that have those, and it would put that issue to bed once and for all. And the nice thing about it is that ruling would come out after the election, so it wouldn't be quite as much of a political football for the Supreme Court. But
yeah, they're not going to feel like they're going to influence an election by deciding it one way or the other, because the election's over. And
they're also going to settle the methodology. And so they might decide, no, you can't ban commonly possessed for lawful purposes semi-automatic firearms. But at the same time, they'll say, and here's how you apply the Bruin methodology. There's no, the state governments, the state agencies are trying to argue that it's a 2-step test, that you actually have to consider whether or not the arm that you're discussing is an arm in the right to keep and bear arms. Like, they're saying magazines are not arms. And so what exactly is a covered arm is the first thing that's going to need to be decided. We believe it's at all arms, including fully automatic firearms. That's a bearable arm. That's not the test. That's just a question. Is it covered by the plain language of the Second Amendment? And all bearable arms are. It may get a little squirrely when you're getting into rocket launchers or grenades or something like this. We don't have to go there yet. We're just talking about conventional rifles, even if they're semi-automatic or fully automatic. Then you ask the next question, are those particular guns dangerous and unusual? Because there is a historical tradition of banning particular firearms that were dangerous and unusual. And by that, and I've gotten in trouble on here before because I've used the wrong term, but I think there was like a pepper blaster and a pocket watch gun, which were probably not safe because they didn't really have safeties built into them. They're very crude firearms. Those are dangerous, or always were dangerous and unusually dangerous because they didn't have the right safety mechanisms, and they were unusual. But semi-automatics are not unusual, and I don't know that fully automatics are dangerous and unusual.
Well, so wait a minute. I just want to make sure I'm clarifying what the terms you're using, because that's a Boolean logic issue. There's a difference between and or.
Correct.
So you're saying they have to be both dangerous and unusual, not dangerous or unusual, right?
And that's another game that states tried to play, trying to make it disjunctive, like an or. No, it's not or. Supreme Court said dangerous and unusual. Those types of guns may be banned, maybe, because there is historical precedent for banning dangerous and unusual guns. There's laws from 1791 where they banned some of those types of things. So maybe that will pass muster. But if it's in common use, and this was what Heller and Bruin were all about, handguns are in common use, you cannot ban them. They are the choice of, it's the people vote. The people vote with their wallets by buying the guns that they think are appropriate for their individual circumstances. And you can't just ban a class of firearms because you've somehow attached an emotion-laden buzzword to it like assault weapon and demonized it as something that it isn't. But we're going a little afield.
Yeah, we are, but that's okay. Just to clarify it, though, that they, just so we understand the fight, part of the fight is they're trying to say that certain things are arms, certain things are not. For example, they're saying magazines are not arms, suppressors are not arms, armor is not an arm. That's the road they're going to go down. And you're saying, no, sorry, wrong. They're all arms. And because they're bearable arms, they're all arms, whether they're semi-automatic, fully automatic, whether it's a suppressor, whether it's a magazine, whether it's a body armor, whatever.
Right.
They're all arms.
Defensive use too. Body armor too. Defensive armor is an arm. Yeah. So all that stuff is an arm. This whole step one is not supposed to be complicated. It's just, is the conduct covered by the language of the Second Amendment, the right to keep and bear arms, and pretty much everything is, and not just firearms. We're seeing a lot of litigation about knives. But then you get into the second test, and that's where it's a test. The first question is just a question. The second part is a test. This is what got us in trouble before. They had this two-part test, and Justice Thomas said that two-part test is one test too many.
So what's the difference? What's the difference between a test and a question from a legal perspective? Because seems to me like they're both questions, but I don't know.
You have to pass a test. You just have to answer a question.
Well, this explains why my grades were so terrible. Okay. So, but what does that mean procedurally? The question is, so when you're asking a question, what's the difference between that and passing a test?
You don't get wrapped up in that stage one. You don't get wrapped up there. You move right to stage two. And by the way, in the process, that shifts the burden to the government. The government has to prove that it's dangerous and unusual or not commonly possessed or whatever other justification they can come up with for banning it. But if they wrap you up, when they try and wrap us around the axle on stage one, they try and make it our burden to prove that a magazine is.
Okay. Now I see the problem. All right. Thank you. That helped a ton.
That's the big thing, the shifting of the burden, and make it the state's job to deprive you of your right rather than you having to assert your right, which that's not how rights are supposed to work.
And one of the biggest points in Bruin was the fact that it's the government's burden to prove that there's a historical analog. It's not our burden to go find it. Got it. Okay. All right. Well, let's get back to the CCW thing.
Well, obviously, think in broad terms for a second.
Yeah.
You've got three different basic, generally kinds of laws: bad guns, bad people, bad places. Sensitive places are where they're saying these are bad places for guns, so we want to ban them there. We have the Rahimi case. That was a bad person. We want to ban guns from this guy. And then we've got bad guns. Oh, semi-automatics are bad. Magazines that can hold over 10 rounds, those are bad. We want to ban those. So those are the three groups of cases that we're battling in. The May and Wolford and Caballero's case happen to be sensitive places, so they come under the bad places.
Got it. Okay.
But it's all part of an effort by the gun ban lobby to work every angle they can to ban as many guns from as many people from as many places as possible.
Well, I mean, obviously, with concealed carry, the goal is to make the concealed carry permit useless because you can't carry the gun anywhere.
Right.
I mean, to make it simple, if everything is a sensitive place except the inside of your house, what the heck do you need a concealed carry permit for? Because you can't leave the house with the darn thing anyway.
Right.
So that's exactly what they're doing. All right. So you got some things we won here: hospitals, churches, medical facilities. I find that interesting. Because sometimes hospitals, particularly in emergency rooms, they'll warn you or
well, remember, this is just what the state can't do.
Right. The hospitals are private property. They can do what they want.
Yeah, anybody
Right.
can. I can tell you you can't bring a gun in my house if I decided to. I mean,
Yeah. Brother, you're welcome to bring a gun in my house anytime you want, just so that you
yeah.
know it's
Let me
okay.
see it. Is it cool? Let's look
Is it
at
cool? What do
it.
you got? Right. And then you said public transit is where the state can't ban that now. Gatherings that require a permit, so that's things like, you got your kid's birthday or whatever, okay, but that could run afoul of the park thing. Parking areas attached to those places, and that was a big deal because medical facilities were a problem.
Right.
Because if you couldn't go in the parking lot of a mall because you didn't realize there was a chiropractor's office in the mall, then you couldn't be in the parking lot. So that really got very convoluted. What is the vampire rule? I keep hearing that term. What does that mean?
Okay, so here's another clever little ploy that Newsom and his groupies came up with. They wanted to force on all private property. They wanted to force the business owner to post a sign that says guns are allowed here. Now, you can imagine how some store owner is going to, who's going to go take the time and trouble and potentially create a stir with some of his customers by posting a signs that say your guns are allowed here. So it basically, the vampire rule is you can't go in. A vampire can't come into your house until you give them permission. That's why it became known as the vampire rule.
I'm never letting a vampire in my house. He can't come in. Okay, so
Right.
that
So
kind of turns.
what this turns it around to is, like in Texas now, a private property owner, a store owner, a leaseholder can post a sign that says no guns allowed.
Sure, that's the same in California, right?
Yeah.
A store, whatever.
But,
sure.
but you can't make them post a sign that says guns are allowed.
In other words, it has to be what they wanted to make it be is an affirmative approval.
Correct.
And by default, you couldn't do it unless you had the affirmative approval of the sign. Is that what you're
Because they
saying?
know most people aren't going to post a sign that says, most store owners aren't going to post a sign that says guns allowed, because it's going to freak out the straights.
Well, most store owners don't post a sign that say guns aren't allowed. To be honest with you, in California, I don't see those very often. I guess the other question I have for that, where these provisions are concerned, is typically, at least at present, as far as I know, if you walk into a store and there's a sign posted, maybe you don't see it and you walk in, it's a trespassing violation if
Right.
you're asked to leave and you refuse to leave. That's 602 PC. It's a misdemeanor, and it's only a violation if you become aware of the fact that that the store doesn't want you there or the private property holder doesn't want you there and you refuse to leave. Does this vampire rule, if it went through, or any of these other restrictions that we lost on, do these suddenly become firearms violations that could put us at risk of losing our firearms rights if we're found guilty of them, or are they still trespassing violations?
No, it's two different laws. This creates its own punishment if you possess a firearm in those banned areas. Those even with the CCW, if you possess a firearm with a CCW in those banned areas, there can be a trespass, there can be a license revocation, there can be a criminal prosecution for possessing the firearm in a prohibited place. So
does this put your firearms rights at risk for the rest of your life if you're found guilty of doing this?
Well, it could, depending on how the court viewed the circumstances and what kind of probationary conditions they wanted to impose or something like that. But I think that's going to vary a bit depending on what the circumstances are. But the point is, you got to be careful, and you got to know where you can and can't, and you also have to just be discreet.
Yeah, I think concealed means concealed in case you accidentally screw it up. So, but just to clarify, with the vampire provision, we won on. That did not go into effect. So we're not expecting that we have to, in order to go into a store, we have to look for a sign that says guns are okay.
Correct.
That didn't succeed on the part of the anti-gunners. Is that correct?
Yes, that's right.
Okay, so just to go through the list again, we're okay unless the private property owners tell us otherwise. We're okay at medical facilities, hospitals, and churches. Now, I just want to stop there. If your church does not have its own building and they rent a school auditorium for church on Sunday or Saturday or whatever, as far as I know, state law says a school is a school is a school 24/7, 365, and even though you're renting it as something else, it's still a school. So I don't think you can carry a church during church at school, can you?
Generally, you cannot. If there's a school at the church, the school, by virtue of the fact that there's a school, you're in a school zone, so you can't carry there.
But if you have a church and you don't have a building, you rent the school, a high school auditorium on Sunday, for example, for your church service. The high school is still a high school, even though school is not in session and it's Sunday.
Yes.
So that makes not all churches are created equal where this is concerned. Your mileage may vary. Okay.
And you got to remember again, I mean, the church, some churches embrace firearms in the church because they recognize that that's good self-defense practices. Yeah. And it's certainly played out several times that you've seen on social media where someone comes in, starts shooting, and gets put down pretty quickly. But they are private property. Private property is a separate set of rules. That's where you get into the trespass. If you take a gun in a place where it would be allowed by state law, but the owner says you're not allowed to have guns on my property, that's a trespass. So, private property owners can prohibit guns on their private property. We're talking about state action here, what the government can and cannot.
Right, you're right. So there is a difference. Okay, so public transit, the state cannot ban carry there. Obviously, the transit organization, Metro Transit Organization, can do so if they wish, but the state can't do it as a blanket thing. Gatherings where permits are required, again, the state can't do it as a blanket thing. The parking lots attached to those areas, which is absurd, and I'm grateful that we didn't lose on that. And the whole vampire rule that would require a store to put up an affirmative sign that says you can carry here did not make it either. We won on all of those. Let's talk about where we have to go back and fight more. One is bars and restaurants that serve alcohol. So if I go to any restaurant that serves alcohol, even though nobody in my party is drinking, then I still can't legally carry there. Correct me if I'm wrong on any of these. Playgrounds and parks. I take my kid to a public playground or a public park. I'm not supposed to carry there. State parks. Does that mean, like, if I go hiking in the Laguna Mountains, I can't carry? I mean,
this is where it gets particularly problematic, and frankly, we're going to need to get the trial court to clarify some of this. What do you mean you can't carry in a state friggin' park? I mean, that's you're camping, you're hiking,
you're hunting.
You're hunting. I mean, this is kind of ridiculous, and I don't know. We're going to have to go back now and take a look at how it conflicts with hunting laws and firearm possession laws in parks, federal and state parks. They all have different rules on what firearms you can have, where you can have them. But generally, you can have a firearm in your campsite when you're in the middle of the woods.
Okay, so between you and me and the grand piano and everybody watching this show, because I teach the concealed carry course for the San Diego County Sheriff's Department and have for, 2 decades, I actually went up to the Laguna Mountains and I talked to the state rangers up there and asked them if it was okay to carry there. And without exception, they all looked at me and said, if you have a concealed carry permit and you're not carrying while you're hiking out here, you're an idiot.
Yeah.
And I said, are you concerned about four-legged predators or two? He said, well, I mean, we have had more problems with mountain lions, so I guess a little bit four, but in a lot of cases two, because you could stumble upon somebody that's got some sort of a drug operation going out there in the boonies or whatever, and you can call them if you want to, if you have cell service, which you very well may not, and it's still going to take them an hour and a half to hour and 45 minutes, 2 hours to find you and locate you and get there. So you are on your own. So by virtue of saying you can't carry while hiking, camping, whatever, in some of these rural areas, they really put citizens at a horrible disadvantage. And that's a crazy law.
This is a point I made to some of the reporters I was talking to. What they've basically done is all these places where they said your CCW is invalid, you can't carry a gun there. That's now that's now a criminal empowerment zone. That's where victims cannot defend themselves, but criminals who don't give a damn about what the law says about whether they can have a gun there, they're going to have one, and they're going to have no one to stop them from committing their violent crimes.
Well, and the rangers are not going to be out there, looking for people carrying concealed firearms. They're not going to walk up to you and ask you in the first place. And they're having trouble catching the criminals with them. So, I mean, that's crazy. All right, casinos, stadiums, and arenas. Most of them, like MLB, does not allow you to carry guns during the game. Most casinos in California are on federal land because they're on reservations, and the reservations don't particularly want you there. What I find interesting about that is I don't know whether the state has the authority to ban those on federal
Indian
land. On Indian land.
Yeah, it's Indian law.
Right. If you ask the Native American tribal government, they'll tell you that oftentimes on so many of these things, the state can go pound sand. So I'm not sure that they have the ability to do that, but they're trying. And then libraries, zoos, museums, and the parking areas attached to those. So when we get to these parking areas, you mentioned this. Where the heck do you park? So you're carrying your gun all day, and you're trying to be super responsible, and you buy a gun safe with a cable or something that attaches it to your vehicle so it can't be seen, it's not there, and you decide, okay, I know I'm taking my kids to the zoo or whatever. We have a famous zoo here in San Diego. I'm going to take my kids or my grandkids to the zoo. I know I'm not supposed to carry there, so I'll stop before I get there so nobody sees me do it, and I'll put the gun in the safe, lock it up. I'm being a responsible citizen. I'm going to go park in the zoo, take my kids to the zoo. I can't do that because it cannot even be in the parking lot. Am I getting that right?
That's the way it seems from the Ninth Circuit's ruling, and that's another thing that we're going to have to go back to the trial court and clarify. You know, what a lot of these parking lots are not. They're not owned by the same venue that operates.
Right. That's the other thing.
So, yeah, this is a, close enough for government work kind of a thing. But
so let me ask real quick, just technically now. So that I get where we're at, because I don't. I'm not an attorney, and I don't play one on YouTube or Rumble or X or anyplace else. So we won at the lower court on all of this. The state petitioned the Ninth Circuit to review it. We went to the Ninth Circuit on a 3-judge panel, which was a terrible panel. I realized that just from watching posts on X, yours and others. We actually did. I mean, truthfully, I didn't think we were going to win on any of these things with that panel.
I didn't think we were going to.
So I applaud you and everybody else involved. You guys did a great job winning on the things you won on. Not that the fact that we didn't win on anything doesn't suck, because it does, but you actually freed up a lot of stuff. I'm very, very grateful. But that was the state petitioning the Ninth Circuit to get a preliminary injunction to defeat the victory we had in the lower court, so that so they could basically wipe out that win as this is litigated.
Yeah, they wanted to knock out the preliminary injunction.
And so what happened was they were able to knock out part of it,
right,
but not all of it. So this is still being litigated in court, though, because we don't have a final judgment. So this isn't the final decision. We're done. Is that
correct? And we will go back down to the trial. I suspect we're brainstorming and having meetings about the pros and cons of all the different approaches with 3 different cases early next week. But I suspect what we're going to do is go back down to the trial court and point out some of these issues about the dumb consequences of some of the positions that the Ninth Circuit has taken, and some of the realities of this, and have the trial court rule again on a permanent injunction, one way or the other, and then we'll be up on appeal again.
Now, if you go up on appeal again, do you go back to the same 3-judge panel, or can you get a different one?
Probably. You probably
yeah.
But that's why I say, there's a lot of cases in different stages of progression, and the 2 that are furthest along right now is Bianchi and Duncan in California, or perhaps Antonuc in New York. That's another sensitive places case, which might get to the Supreme Court faster. Yeah. So it's not this is not one case. We're talking about dozens of cases across the country on those 3 different topics: bad people, bad places, bad guns, and all of them are intertwined, and all of them are precedent and can affect other cases in other states and other issues. So it's a big fight, and I appreciate everybody who's supporting the CRPA or the Second Amendment Law Center. To carry on that fight.
So, Chuck, I'm sorry, I'm interrupting you. I apologize. I just know we're short of time. So I want to ask, and yes, you should be supporting CRPA. If you're not already, please do. I will put a link in the description, even if you're not in California, because what happens in California tends to affect everywhere else. So these fights are vital. And as Chuck has alluded, these things are interconnected across the country. So let me make sure I understand. If and I'm hoping this is going to be the case, if the Supreme Court takes one of these other cases, and in the process of, like the assault weapons case, and in the process of deciding that, they make the decision to clarify what the rules are and the procedures are where Bruen is concerned. Does this make it then more difficult for the Ninth Circuit three-judge panel we just had, or some other anti-gun leaning justice or group of justices to play the kinds of games that they're playing currently?
Yes. And I think that at least 4 of the judges on the Supreme Court want to try and put a stop to that. They were sick of what happened after Heller, and they tried to sort of rein things in with Bruen because Heller was abused, misinterpreted, and misapplied. They tried to rein it in with Bruen, but they're playing the same games. The judges who do not like gun ownership, do not respect the Second Amendment. They're playing the same kind of interpretation games of Bruen that they played of Heller. And so I think that the Supreme Court really needs to clarify a lot of the things in clear black and white, like, here, listen here, dummy. This is what we're saying, not like in a way that can be interpreted differently so that they stop some of these shenanigans. And last month's Firing Line had a big article about how the Ninth Circuit was playing games with the en banc panels and interpreting Bruen. So this is
they're going to continue doing that regardless of what the Supreme Court does, because it's not. I mean, that's not going to matter a hill of beans.
Well,
it's going to make it harder.
Yeah.
Right. It's going to make it harder. But if they wish to play games, they're going to continue to play games. I think to assume otherwise is foolhardy at best. My hope is that, as you say, the Supreme Court will continually make that tougher and tougher as time goes by. In the interim, and then I know we're kind of running short of time here. Let me just run this, because I hesitate to even say it. But if you're carrying, concealed means concealed. If you have a concealed carry permit in California, most of the people I deal with that have them are law-abiding people, and they're trying to do what the law requires, even though they think it's nonsense.
Right.
But I can see and hear in some of these places where it would be very, very easy to inadvertently find yourself in a sensitive place, not even realize you did it.
Yes.
And so for that being the case, I would say 2 things that I might suggest for people who are carrying. One is, make sure the gun is properly concealed, so that if you find yourself accidentally in a sensitive place, you're not going to get grabbed because somebody knows that you're carrying the gun. That's the first thing. I think the second thing would be, if you have some sort of concealed carry coverage, I would look through the coverage policies on those and speak to those companies and ask them, okay, I have coverage. If I find myself accidentally in a sensitive place, which I didn't know I was in, and I have to defend myself, are you going to defend me, or are you going to drop me like a hot rock? I'd be having that conversation as well, because I suspect some of these companies, one I'm aware of has already dropped a couple of people, might just drop you like a hot rock. So if you're carrying a gun in California, you have a permit, my advice would be investigate that with your, for lack of a better term, insurance coverage, and make sure that they'll actually protect you.
I think another thing that folks should keep in mind is, if you find yourself in one of these areas, the conventional way to transport a firearm is unloaded and in a locked container. So you can unload the gun, put it in your trunk, make sure the magazine is not in the receiver, and lock it up, and you're going to avoid a lot of trouble. Even if you get caught with that, it's going to be mitigating circumstances, if not exculpatory. So That's how people without a CCW have been transporting their firearms for forever.
Explain exculpatory. I don't know what that means. I suspect I'm not the only one.
Gets you completely out of trouble. They may not bother trying to prosecute you, or in some places, by unloading the gun and putting it in a locked container, which is the conventional way to transport a firearm. Remember, the CCW just gives you a license to carry a concealed firearm loaded.
Right.
Not in a locked box, carrying it in a holster. Ordinarily, the way you have to transport a firearm is unloaded and in a locked container so that it's inaccessible to you, and it's not loaded and ready to fire. It's not like there are some places where you can't have guns at all, some places where you can have guns if you store them properly, and other places where you can have guns if you and have them loaded and ready to go if you have a concealed weapon permit. So what I'm saying is, if your concealed weapon permit becomes invalid in some area, the best fallback, other than leaving, is to have it unloaded and in a locked container so that you're transporting it the way it's supposed to be transported otherwise. Now, that may get you out of trouble completely. If not, it'll at least be mitigating. No prosecutor is going to say, oh, this guy was getting ready to do something bad because he had a concealed firearm ready to go and his permit was invalid.
And we're hoping that this problem is temporary, because the battle to get more relief is ongoing. But at the moment, you want to make sure that you don't lose your firearms rights or your permit or whatever over this stupid stuff. And if that means you decide, well, I don't want to go if I can't carry, and you decide, well, heck with it, I'm not going to the zoo. I won't take my kid to the park. I won't go hiking or whatever. That's entirely up to you. But I think the advice that's been given is very positive as far as how to stay out of trouble in the first place, because California, they're looking for reasons to restrict your rights in every way. And I think if you get caught doing this, then they're going to go after you, probably, depending on where you are.
A low profile is the way to be. Just be discreet.
Absolutely. Anything else we didn't talk about that we should cover, Chuck?
Well, there's a lot of other cases. We should probably do that another day. Let's. We have Rhodey, the ammunition background check, Duncan, the gun show cases, the Junior Sports Magazine marketing to minors cases. There's a lot of things going on in those cases. Maybe we should do a recap next week.
Absolutely. I look forward to that. Just let me know what your schedule is, and I'll work around it.
Okay, great.
All right, brother. Have a great day.
Joel, always a pleasure. Thanks for having me.
Thank you very much for watching the whole video. I'm very, very grateful that you did. I hope you have a wonderful week, and I hope you will go join me on Rumble and X, or Rumble or X. Rumble's where all the videos are and will continue to be, including Rumble videos that can't appear, simply cannot be on YouTube. They'll be on Rumble. They'll also be on X, and then X I'm on quite a bit and commenting on things. So if you want to hear about my opinions on stuff, you can go follow me over on X as well. There are links in the description. Please do support CRPA. They're doing some great work, and you'll find a link for that too. And I think that's about it. Have a great week. Thank you so much. And wherever you go, whatever you do, stay safe.